We're going to be focusing today on what, in my experience, has been the single most frequent type of legal dispute that buyers, sellers, and investors of real estate get involved in, particularly in times of hot real estate markets like we've been experiencing for the last several years, and that is non-disclosure claims. Claims that something has gone wrong in the disclosures that sellers were supposed to have made in connection with the transaction. And my name is Phil Diamond. I am a real estate lawyer. I handle real estate disputes and transactions, and I am of counsel to Cunningham Legal. I grew up in Southern California, came up to Cal Berkeley as an undergrad, went to Boalt Hall School of Law, as it was then known, at UC Berkeley. I was an associate editor of the California Law Review. Since then, I have been a past director of the Marin County Bar Association and a past chair of the Marin County Bar Association Alternative Dispute Resolution section. I am also a mediator and an arbitrator, and I have an independent practice, Diamond Dispute Resolution. I'm also a licensed real estate broker, although I use the license for my own purposes, not for others. And I'm also a real estate investor. Here are the other attorneys in our firm. We have offices throughout Northern and Southern California. We also have a YouTube channel for those of you who aren't familiar with it. Go to Cunningham Legal on YouTube, and there are dozens of remarkable webinars that are posted on that channel on a number of issues involving the other areas in which our firm practices, which deal with estate planning, trust administration, and tax. And if you enjoy this webinar today, it's going to be posted on that channel this evening. If you enjoy it, please go to the channel and subscribe. Because I am a lawyer, I do need to begin this presentation with a disclaimer, and that is that I'm talking with you today solely about general information regarding the issues we're going to be discussing. This is not legal advice. I am not your attorney. And as I said at the bottom of this slide, don't watch this and go out and do a bunch of stuff on your own without getting legal advice first. And obviously what I mean by that is if you have a particular situation that you need legal advice from, please go to your lawyer. And if for some reason you don't have one, we'd be happy to talk with you. So let's begin with some basics in order to tee up this conversation. First of all, when I'm talking about real estate, that's just another way of saying real property. And I'm distinguishing real property, which is structures and land, from personal property, the things that can be moved. In general, there are two types of real estate. The first is residential, and that typically involves structures with 1 to 4 dwelling units. And the other general category is commercial, which is usually referred to as having office, retail, and industrial included in that definition. Multifamily apartment buildings are also typically referred to as commercial real estate, although there is some crossover there because there are, of course, landlord-tenant issues involved with multifamily as well. The reason that I mention all of these is that the non-disclosure issues we're going to be talking about today are important for all of them. But today's webinar is going to focus solely on residential real estate. So if real estate is such a good thing to buy, and obviously it is, that begs the question, what could possibly go wrong with residential real estate? Well, unfortunately, the answer to that question, and I know this from many years of experience in this field, is that a lot can go wrong with real estate. I typically define these as involving the following issues of types of things that can go wrong. First, there can be physical issues with a property that can result either from construction defects or from deterioration over time. And that can lead to problems such as water intrusion, which can in turn result in mold problems. It can result in termite and dry rot issues. It can result in structural issues such as problems with foundation or other structural members of the property. Other physical issues could involve indoor environmental issues. And what do I mean by that? I'm talking about things such as asbestos exposure, lead paint exposure. Sometimes people bring claims involving second and third hand smoke issues, and the list goes on. So that's just the physical issues. There can also be use issues. What do I mean by that? For example, if it is a condo, there can be homeowner association restrictions on how the property can be used. One common area that is involved in disclosure issues is whether there's a limitation on the ability to rent the property. And oftentimes HOAs limit the number of units in the development that can be rented. There can also be limitations by the HOAs on an owner's ability to make alterations to the property. Another use issue that we see sometimes is the ability to use the property that has an ADU, an accessory dwelling unit, or a junior accessory dwelling unit, a JADU, on the property. And some of the claims that I've seen in the past have involved people who have bought a property that has an ADU on it, with the expectation that they would live in the front of the property and rent out the ADU, only to find that for some reason, the ADU is not legally permitted. There can also be legal issues with a property. And by that, I'm talking about permits that may not have been taken out that should have been. There can also be title issues. For example, who owns the property? Does the seller, in fact, have good, clear title? Or are there liens against the property that for whatever reason haven't been picked up in the course of escrow and haven't been disclosed? There can also be property line issues, such as issues involving easements or boundary disputes. There can also be neighbor property issues, such as developments that are planned next door that, when built, can restrict or completely eliminate views that were one of the main reasons that a buyer bought the property. There can also be neighbor property issues resulting from what's referred to as a nuisance. And by that, I'm referring to noise issues, odor issues, and so on. And the reason that I've taken the time to go through all of those types of issues is that all of them and more can be the subject of a non-disclosure claim. The risks to buyers and sellers from improper disclosures involving any or all of those issues or others generally fall into a couple of categories. The first, of course, is financial. There can be repair costs. There can be temporary alternative housing costs. If, for example, the property is one that you're living in and repairs have to be done that force you to leave the property. There can be loss of resale value. There can be a damage claim against the seller, and if it involves investors, and we'll talk a bit more about this later, there can be damage claims among the investors. There can be legal fees, of course, associated with all of those, and the list goes on. And of course, in addition to the financial risks, there's also the emotional risk from all of the above. Dealing with repairs while living in the property, of course, can be a nightmare, and the same is true with living with the litigation process. So the purpose of this conversation today is for me to provide to you what I see as the three most important tips that I can give to buyers, sellers, and investors as to how to avoid all of that. So the starting point of that conversation, first of all, is to give you basically an anatomy of a lawsuit, an anatomy of a claim, the life of a non-disclosure claim, so that you know what it typically involves. It usually starts with the buyer discovering a problem that for some reason wasn't disclosed in the course of escrow. And that discovery of the problem could happen either during escrow or after escrow has already closed. The buyer then notifies either the agent or the seller, And if this happens during escrow, the buyer typically demands a credit for repairs of the non-disclosed items or cancellation of the contract and return of the deposit. If the problem is discovered by the buyer after escrow closes, then the buyer instead typically demands damages for the repair costs and all other associated costs and damages, or what's known as rescission of the contract. And rescission essentially means to undo the deal and put the parties back in the position they were in when they started. And that rescission claim can also include a claim for damages. That typically then leads to informal settlement discussions between the parties themselves, although that doesn't always happen. Sometimes the first step is that the buyer will hire a lawyer, the seller will hire a lawyer, and then there will typically be informal settlement discussions between the lawyers. And if the lawyers are doing their job properly, their goal is to do everything they can to help their clients resolve the matter without having to go down the litigation path. But that doesn't always work. And if that doesn't work, then the next step is what's known as mediation. And for those of you who are not familiar with that, mediation is an informal process where a third-party neutral, who is usually either a lawyer or a retired judge, is hired by both sides to help them to negotiate a settlement that is of their own making with the mediator's help. And if the property has been bought using the California Association of Realtors form purchase and sale agreement, mediation is required by that contract before the parties can take the next step. If mediation doesn't work, then the next step is litigation, meaning a formal lawsuit in superior court, or arbitration if arbitration has been required in the purchase and sale agreement. It should be obvious from what I've just gone through that that process can become very expensive very quickly. It can take months or years to resolve. And unfortunately, the outcome is never certain. No matter how strongly one side or both feels in the strength of their position that they're right and the other side is wrong, there really is no way to predict the outcome at the end of the day, because ultimately, if the parties don't resolve the matter on their own, it will be left to a judge, a jury, or an arbitrator to make a decision for them. A problem, and it's a huge problem that's related to everything that I've just mentioned to you, is that for sellers, this can be what I refer to as a ticking time bomb. And here's what I mean by that. These are typically fraud claims. That is, they are claims that somebody knew something and deliberately didn't disclose it. And we'll talk a bit later as to what the duty of a seller is. The statute of limitations for a fraud claim is 3 years. And that statute of limitations begins to run from the time when the buyer actually discovers the problem, or from the time that the buyer should have discovered the problem. And the problem here for sellers is that the beginning of that statute of limitations, that is, when the buyer should have discovered the problem, may not happen until years down the road. And sometimes that happens when somebody has bought a property, there's no problem with it for several years until they go to do some remodeling. And when they do some remodeling, they start opening things up and find a problem that they could relate back to something that should have been disclosed during escrow. And of course, the other problem for sellers in that situation is that there may be no insurance coverage to respond to that claim, because typically insurance does not cover fraud claims. So with that background, let's now turn to legal considerations for real estate for buyers. And I'm going to start now with 3 of what I view as the most important tips for how buyers can avoid non-disclosure claims and to best position themselves in the event that something does go wrong. The starting point for that conversation is to talk a little bit about a buyer's legal duty in the transaction. That legal duty is to act reasonably in connection with the transaction in order to protect yourself and your own interests. Again, you as a buyer have a legal duty to act reasonably in connection with the transaction to protect your own interest. And what does that mean? Basically, it means not to let your eagerness to buy the property get in the way of your good common sense. And that in turn means you need to do what you can to minimize the risk, which in turn means do everything you can to basically know what you're getting into so that you in turn minimize the potential for surprises. And so now let's turn to my 3 most important tips as to how to do that. Buyer's tip number 1, and this may seem unbelievably obvious, but I'm going to say this anyway, because believe it or not, this does happen. Number 1, never make an offer on a property sight unseen by you. Never make an offer on a property sight unseen by you. And the reason for that is you should always assume that your offer will be accepted as presented. And once it is, you are now in contract with the seller and you have a binding contract. If you've never seen the property, and particularly if you've waived all of your contingencies, which we'll talk about also, you're basically buying a pig in a poke, as the old saying goes. And so you might wonder, why would anyone ever buy a property that they've never seen? Well, the situations in which I've seen that happen often involves, for example, an out-of-state or an out-of-area buyer who is relying on their agent to basically be their eyes and ears and their feet on the ground to go look at the property and to tell them whether this is something that they should be making an offer on. The problem with that is the agent may not see everything, but also there may be things that you are particularly interested in a property that for whatever reason your agent either doesn't know or doesn't remember. And so that when you as the buyer actually then see the property yourself, you find that it's something different from what you thought it was. So buyer's tip number 1, never make an offer on a property sight unseen by you. Buyer's tip number 2, and here's where we talk about contingencies. Waiving all contingencies is almost always a bad idea. But first of all, just again, a basic, what are contingencies? A contingency means that your deal is based upon certain contingencies being satisfied. And those contingencies, and the most important ones for this discussion, are the inspection contingency and the financing contingency. And what they generally mean is that you're in contract for a particular price, but it is contingent upon you having the ability to do your own due diligence on the property by doing your own investigation. And if something happens during the course of that investigation that causes you to want to back out of the deal, you can. So again, the inspection contingency is there to give buyers an opportunity to do their own due diligence. The financing contingency is there so that if for some reason the loan doesn't come through, buyers will have a way to back out of the deal and get their deposit back. So again, waiving all contingencies is usually a bad idea. So then let's turn to buyer's tip number 3. And I can't stress the importance of this enough. This is truly critical. As a buyer, you must read and completely understand the seller's entire disclosure package. The seller is required to give the buyer all required disclosures within 7 days of acceptance of the offer, unless otherwise agreed in writing. And that disclosure package includes the transfer disclosure statement, the TDS, which we'll talk about a bit more in a moment, The seller property questionnaire, the SPQ, we'll talk about that more in a moment as well. Typically, it also includes a home inspection report and a wood destroying pests and organisms, a WDO report, also referred to as a termite report. And we'll talk about those in a minute as well. This is what the transfer disclosure statement looks like on a California Association of Realtors form. This is what the seller property questionnaire looks like, again, on a California Association of Realtors form. The transfer disclosure statement is required by law to be filled out and given to buyers. The seller property questionnaire is not required by law, but it is required in the form California Association of Realtors Purchase and Sale Agreement. So it's required by contract if that's the form that you're using in the transaction, and it is the most frequently used form. The TDS and the SPQ are filled out by the seller and given to the buyer at the beginning of the transaction. And they were developed essentially as checklists for sellers to focus on and to disclose to buyers everything the seller knows about the property that might, quote, materially affect its value or desirability. And let me say that again, materially affect its value or desirability. And we'll discuss that in a bit more detail later. The TDS and the SPQ, in my experience, and I've been doing this for many years, are the single greatest source of real estate non-disclosure claims by way of something either not having been disclosed or disclosed properly in those forms. Sometimes those forms are filled out by sellers by hand, which is fine, but the problem with that is they're not always legible and they're not always clearly written. So, and here I can't stress the importance of this enough as well. If there is anything in the TDS or the SPQ that you can't read because it's illegible or that you don't understand, you should ask your agent to get a written explanation from the seller. Again, ask your agent to get a written explanation from the seller. If you don't, and you later discover a problem that was related to something in the TDS or SPQ that you either couldn't read or didn't understand, but you didn't follow up on, you may have no recourse. And again, you have a duty to act reasonably, and it could well be found that you breached that duty by not asking for further information. So let's turn for a moment now to the home inspection report and the WDO report. And let me start this discussion by just telling you first that these reports are important and they're there for a reason. But you should not rely exclusively on these reports as your sole source of information regarding the property. Now, why do I say that? The home inspection report is done by what's called a home inspector. And that home inspector is trained to go through properties and to find things. But the home inspector is not a licensed structural engineer. He's not a licensed termite inspector. He's not a licensed geotechnical engineer. And oftentimes you will see in home inspection reports that the home inspector has found something that looks suspicious, but he cannot report on what it is because it's not within his licensing. And he'll recommend then that further investigation be done by a structural engineer, for example, or a geotechnical engineer if there are potential settlement problems with the property that might relate to the underlying soils. The other problem with relying on a home inspection report is that the home inspector can see things that are only visible and accessible. Again, visible and accessible. And if things are not visible and accessible, that's not something that a home inspector can see or to report on. And what can be not visible or accessible? Well, simply put, things that are covered up, typically within walls, for example, that may have problems concealed in them, but that can't be seen without opening the wall up. Now, that's a similar problem with the WDO report, again, the termite report, because again, those are limited to things that are visible and accessible to the termite inspector. And oftentimes the WDO report usually will tell the reader that there is a recommendation for further investigation in a specific area. And that usually means having to open up a wall to see what's in that wall cavity. If that's the case, and you buy the property without having done the further investigations or bringing in the further experts that are recommended, and if you buy the property and you later find that there's a problem that you would have discovered had you done the further investigation or had you brought in the other expert that was recommended, you as a buyer may have no recourse. Now, of course, the problem with that is that, and this is oftentimes the case, a seller may not allow further investigation if it requires destructive testing. And by that, I mean opening up walls. And that's for obvious reasons. Sellers are not typically going to want to allow their properties to be opened up during the course of somebody coming to look at property to see whether they want to buy it or not. So what are your options as a buyer at that point? Well, you really have only two. The first is to continue with the purchase and accept the risk if you're willing to do that. The second is to walk away from the deal, and only you can make that decision. So we've now talked about my three most important tips for buyers. I now want to turn to the three most important tips for sellers in order to avoid non-disclosure claims. And as we did with buyers, I want to start with the sellers by starting with the seller's legal obligation. As a seller, you have a legal duty to disclose all facts of which you are aware that might materially affect the value or desirability of the property. And you heard me refer to that phrase with regard to the buyer's issues a few minutes ago. And you might ask yourself, what in the world does that mean, materially affect, or the value or desirability? Well, I have three rules of thumb, and these are not all my own authorship. These you will see frequently. And they are, number one, when in doubt, disclose. Number two, ask yourself, what would you want to know if you were the buyer? And number three, and I think this perhaps is the most important one, if you as the seller are concerned that disclosing something might scare buyers away, that is almost always a clear sign that it is something that must be disclosed for obvious reasons. So those would be the rules of thumb as a starting point as to what needs to be disclosed. I also want to mention that there is a real good discussion of what I've just mentioned means in a form that the California Association of Realtors has prepared that's known as the Disclosure Information Advisory for Sellers. And I'm putting a screenshot of that up on the screen right now. It's a great form. Your agent as a seller should always give you a copy of that. And if for some reason he or she hasn't, make sure to ask for it and make sure that you get it. And you should think of your disclosure package as a seller as being your best friend. And here's what I mean by that. A complete and accurate disclosure package is your best protection to minimize the risk of being on the receiving end of a non-disclosure claim and to maximize your chance of successfully defending a claim in the event that there is one. And you, again, should think of the transfer disclosure statement and the seller property questionnaire as your best friends in thinking about what you need to disclose. So that then in turn begs the question of when do you disclose? Well, by law, you're required to make these disclosures within 7 days after an offer is accepted or is otherwise agreed in writing. But giving potential buyers your disclosure package up front, and that can be, for example, with the MLS listing with a link to that, that gives you the ability to say that you've already factored everything that is revealed in the disclosures into your list price. And doing that gives you an obvious advantage in negotiating leverage in the event that a buyer, for whatever reason, wants to negotiate the price down due to something that they found in the property. And I would also mention that having the full disclosure package before making an offer might also make potential buyers more comfortable with waiving contingencies with their offer. Now, again, as I said earlier, when we're talking with buyers, we never recommend waiving contingencies, but sometimes that does happen, and having the full disclosure package at the time that the offer is made may make buyers more comfortable in doing that. Let's turn now to how to disclose. And by that, I mean not only what you say, but how you say it. And the two goals here are, number one, to make it completely understandable, that is, make your disclosure completely understandable in your TDS and SPQ. And number two, of course, to make it completely accurate. If your TDS and SPQ are handwritten, and this is obvious, but I'm going to say it anyway, make sure that your handwriting is legible. And most importantly, stick to only what you know. Stick to only what you know and do not make any assumptions or overstate what you know. And here is an example of the right way and the wrong way to do it. The wrong way would be, and this has to do with a roof leak, quote, "We had a prior roof leak into the living room when it rained, but it's been fully repaired." So what's wrong with that disclosure? Well, first of all, you don't know that it's been fully repaired unless you were the one that actually did the repairs. So the right way to make that disclosure would be, we had a prior roof leak into the living room when it rained. We hired ABC Roofing Company to fix the roof, and we haven't observed any further leaks since that was done. And we're attaching a copy of ABC Roofing Company's estimate and invoice. So in that disclosure, you're telling the buyer everything that you know, but you're not telling them things that you don't know. And as importantly, you're also giving the buyer the actual documentation from the people who actually did the work in support of what you're telling them. And in doing that, you should think of your TDS and your SPQ as what may someday become exhibits 1 and 2 to a jury. So again, make sure that those TDS and SPQ forms are filled out properly and accurately. Now, if you need help in preparing your disclosures, you should consult with a California real estate attorney, and we do this frequently for our clients. And you should not, and I don't know how better to emphasize this, you should not be asking your agent, your real estate agent, to tell you how to fill out these forms. Your real estate agent cannot and should not tell you what to disclose or how to disclose it. Doing that is bordering on practicing law without a license. And if you were to ask your real estate agent for help in that, your real estate agent should tell you, "I'm sorry, that's not something that I can help you with. You should consult with a real estate lawyer." And if you do have a real estate lawyer, obviously that's the person you should go to. If you don't, we'll be happy to discuss any of those issues with you. So let's turn now to seller's tip number 2. And that is, as is doesn't mean don't disclose. As is doesn't mean don't disclose. What do I mean by that? Well, virtually all purchase and sale agreements are as is agreements. And that means that you are selling the property in its current condition, and you are not obligated to make any repairs to the property. Now, if the buyer hasn't waived contingencies, and after you are in contract for a set price, the buyer finds something that is wrong with the property, and the buyer wants you to actually give a credit for or to pay for the repairs or to actually do the repairs before escrow closes. As a seller, you don't have an obligation to make those repairs. Rather, your alternative is, if the buyer won't close the deal without the repairs being made or credited, you just don't go through with the deal. But that doesn't mean that you didn't have a legal duty to disclose all facts that you know about that might materially affect the value or desirability of the property. So again, as is does not mean don't disclose. So now let's turn to seller's tip number 3. The buyer's inspection contingency waiver, just like the as-is provision, doesn't mean don't disclose. Even if a buyer has waived the inspection contingency, you still have a legal duty to disclose all facts that might materially affect the value or desirability of the property that you know about. And the buyer could still sue you for damages or to undo the deal if you don't disclose an important issue, and the buyer can prove that they would not have entered into the deal in the first place had you made the disclosures that you were required to make, and that is regardless of whether the buyer has waived the inspection contingency. Now let's turn to the third topic, which is legal considerations for real estate investors. And what I'm going to turn to now are my 3 most important tips for real estate investors to avoid non-disclosure claims. Investors tip number 1. Whether you're doing a fix and flip or a hold and rent, everything that I have already told you as a buyer or a seller is even more important, more critical for you as an investor. Why? Because a bad investment decision can not only cause a huge financial loss, it can also result in disputes with your partners and co-investors. So keep in mind these 2 true sayings that I tell clients all the time, and that is, when you're doing real estate for a living or as an investor, you make your profit when you buy, not when you sell, and fall in love with the numbers, not the property. And what does that mean? Both of those basically mean that you need to know exactly what you're getting into, or as much as you can about what you're getting into, before you buy the property, so that you can then meaningfully assess the risk and the costs associated with having to deal with any problems, because all of those have to be factored in to the profit that ultimately you're going to be making on the back end. And the only way to do that is to know as much as possible about the property before you buy it. Now, in doing that, you're going to have to strike a balance between risk and reward. And what I mean by that is striking a balance between knowing as much about the property as possible against the potential for losing the property to another investor or another buyer buying it for his or her own interest to live in it. And you're just going to have to make the decision in striking the balance between risk and reward as to whether this is a deal you want to get into or not. And typically that is going to involve your risk tolerance as well as your financial capacity to deal with the perceived or actual risk. So now let's turn to investors tip number 2. And this is directed to rehabbers. if you're doing a rehab, a fix and flip, make sure all of your repairs are done properly by qualified, licensed contractors. And let me say that again. Make sure that all of your repairs are done properly by licensed, qualified contractors who are doing the job that they're supposed to be doing. The old saying, don't put lipstick on a pig, in this situation means don't cover things up, hoping that at some point down the road, it will never be discovered. And sometimes where we see that is where a rehabber or a rehabber's contractor will find some dry rot or mold on an interior wall, and rather than fixing it, not only on the surface, but if there is interior damage, opening up the wall and fixing the interior damage as well. But instead of doing that, just simply literally painting over the problem and making it look good. You should assume that at some point, everything that has been covered up will be opened by a buyer, either because a problem is going to manifest itself either through a leak or through mold coming back out again to the surface, or with the buyer doing remodeling, which is going to require opening up the walls. So again, for rehabbers, make sure that your repairs are done properly by properly licensed and qualified contractors, and assume that anything that is covered up is at some point going to be uncovered. And again, when you're doing those repairs, and again, this is for rehabbers, fixed does not mean, quote, don't disclose. If you fix something, you still have the duty to disclose the underlying problem if it might have materially affected the value or desirability of the property. And with regard to fixing things that require a rehabber to have a contractor to make significant repairs, those are almost always things that could be considered things that would materially affect the value or desirability of the property and must be disclosed. So again, make sure your disclosures are 100% accurate and complete. So then finally, let's turn to investor's tip number 3. If you are using real estate as an investor, you are essentially operating a business. And like any business, you need a team of professionals to help you be successful. For this type of business, obviously, you need a contractor, a licensed contractor, to help you with repairs and improvements, as well as estimating repair costs when you're evaluating what your purchase price might be. You're going to need a good real estate broker to help you with the purchase and the sale of the property if you're doing a fix and flip. You're going to need a good insurance broker to help you with all of the insurance coverages that you're going to need in connection with what you're doing. You're going to need a good CPA to help you not only with your books, but also with the tax issues that are involved with these deals. And as importantly, you're always going to need a good real estate lawyer to help you with disclosures, with your contracts, with joint venture agreements if you have partners that you're dealing with, to help you with disputes if you get involved in disputes, and also to help you with regard to an LLC operating agreement for the entity that you should form as the owner of that property in order to protect yourself from claims against you individually. And by the way, in that regard, and we always recommend that if you're doing real estate as a business, you should always do it through an entity rather than in your personal name or in the name of a trust. By the way, in that regard, there is a wonderful webinar on that topic. That is what real estate investors need to know about using LLCs in real estate investing. That is on our YouTube channel that Jim Cunningham did a couple of weeks ago. So I highly recommend that you go to that YouTube channel and take a look at that webinar. So with that, we've gotten through all the topics that I wanted to discuss with you today. Again, we have offices throughout Northern and Southern California. If you have any issues or concerns regarding any the things that we've talked about today, or problems that we can help you with, we are here to help. Again, we have a YouTube channel, and if you like what you saw on this program today, it will be posted later this evening on that channel, and we would urge you to go to that channel, and if you like what you see, please subscribe to it.